Hey everybody, welcome back to the Court of Random Opinion. My name is Neidigh. I'm here with my friend Omar the Tilted Lawyer, who actually has a whole intro for his show, but I don't have that song and dance for you guys, so you know.
Oh boy, do you hear my daughter's crying in the background?
I can't tell if you're serious or not. No
No,
problem.
something happened. No, it's not real crying. It's like the fake crying.
Fake crying. How do you know if it's fake crying or real crying? I don't have kids.
You just know. It's
Do you
just
need to
one
go
of those
check on
things.
that? Because I can, sit here and clown on you while you're gone.
Yeah, give me 30 seconds. Let me just go lay
No
down.
problem.
I'll be right back.
Lay down the law. Be gentle. Jesus. He's got $2 or $3, I think. Okay. So, guys, while Omar's gone, he and I are meeting in person for the first time in a week, which is weird because you would think I've known him forever. But I've actually never met this man in person. We've only ever done YouTube together. And I was telling somebody else this the other day, and I can't remember who I was talking to. But it's like I remember the first time I saw Omar on a stream, and we were covering this Laura Owens case. And I was like, damn. I was so frustrated with him for some reason. I can't remember what it was. I was like, damn, this guy sucks. And I just left. I just left. And then I gave it a second chance and I was like, oh shit. And now we're friends. So pretty cool. Wait, Bruce is telling jokes over here. Why did the whale blush? Because it saw the ocean's bottom. Ah! Oh my gosh. You must be nervous. Honestly, not really. I'm not nervous about this guy. He's fine. Yeah, but so we're doing like a charity thing. So we're gonna be racing in his mom's pool, and I think his choice for the second contest was arm wrestling. But I can't arm wrestle that guy. Look at that guy, and look at me. So I was like, we gotta arm wrestle with foam fingers. And then the third one, somebody said karaoke, but I'm not sure if that's gonna be that. But we'll see how that goes. I'm gonna have to work while I'm out there. I'm only gonna be in LA for 3 days, and then I fly to Sydney. So yeah, it's gonna be fun, though. So yeah. Omar has kind of perused the documents we're about to go over. Um, he was in Mexico on vacation with his family, so it's the what was the first one? The motion for sanctions. I know Blake Lively filed a motion for sanctions against Justin Baldoni's attorneys and most of the Wayfarer parties, minus Justin Baldoni yesterday. And Ryan Reynolds filed the same today, and those documents are largely the same. So we'll go over that. But the really interesting thing that he hasn't seen yet that we're going to go over is the motion to compel, the second motion to compel, which she's asking for these documents and recordings relating to that internal investigation that Wayfarer Studios is doing. So when she tried to, force them to sign that 17-point list or whatever, they signed the list and she agreed. She was like, I'm going to forego like a formal complaint or forego a formal HR process. And then she, of course, decided, no investigation or anything like that. And then so now they're doing an investigation because she did make a formal complaint when she went to the CCRD. And now she's trying to shut that down. So it's kind of interesting because it's like, well, you are sitting here on talk shows championing yourself as like a fighter for women and girls, but you're also behind the scenes trying to shut down an investigation into your sexual harassment claims. So I don't think Omar knows what I'm talking about.
No, I know what you're talking about.
Okay.
I know what you're talking about.
All right.
I heard something about her trying to shut down the CRD investigation.
Oh no,
But
it's not that. It's a whole separate thing that she's still trying to shut down. It's like an ongoing investigation into her claims. So we'll get to that in a second.
oh,
Anna Banana, thank you for being a member. Lottie, thank you for being a member. I appreciate you guys. And Inoli Usti, thank you for the 10. I love y'all both. Also, happy vacation. Thank you very much. I appreciate you. I was just telling them how we've never met in person, and we will in a week. So
I'm fucking ready for you.
I'm so nervous about meeting your dad.
Oh, I was gonna send you like my training videos, but I thought better of it.
I'd rather see his. No spoilers. Don't send me your training videos. No spoilers, man.
No, man, I'm so fucked. There's nothing so.
You'll be fine. You'll be fine.
I'm ready for what's coming.
If you guys haven't been around for a while, Omar agreed to this because I said I needed a reason to keep going to the gym. And I was having a rough time 4 or 5 months ago. And I was like, I need a reason to keep going to the gym. Let's do this. And he's just like, all right, cool. So, I mean, win or lose, you're kind of the MVP of this one. So
we also got like 4 different alternatives if the swimming thing don't work out for whatever reason. Because
We'll
you're
see.
flying in like or you're coming in over like on a Tuesday or something, and
Monday, Memorial Day, I think.
oh, like on Memorial Day, it's
I fly in on Memorial Day, yeah.
All right,
Because
well,
I had to fly on a day that I don't work, so because I have to work while I'm there in my hotel room.
is Omar in LA or San Bernardino? I am in Nunya.
All right then.
My law firm is in San Bernardino County, and I live right off the Foothill Mountains, in between San Bernardino and LA counties. I'm like in the middle.
I don't even know how far away that is.
From LA, it's like, well, without traffic, it's like a half hour.
Right.
But more realistically, a couple hour drive because there's always traffic.
I'm just hopping in an Uber. I don't give a fuck. So
I need another vacation. I'm not ready.
You just got back, bro.
Bro, it's just I picked up a couple cases today. They are wild. I wish you could talk about them. I wish I could, but I can't.
You can't. Attorney-client privilege or whatever.
Yeah.
All right. So we're taking a look first at this motion for sanctions. And I know that you said, so Omar has not had time to go over these documents, you guys, but he did listen a little bit earlier when we were talking about Ryan's motion for sanctions, which is largely the same as Blake's motion for sanctions. So as far as the Rule 11 sanctions go, I felt like a lot of these points were the same that they were making in the motion to dismiss. And as a layperson, I'm a little confused as to why this is happening now. Why are they he has not ruled yet on any of the motions to dismiss. So why are we now going for sanctions with the same arguments? I'm confused. If you could help me out with that.
No, that's a fair question because, they raised this stuff in all of their 12B6s, which are still pending. And then Judge Lyman issues a ruling on the motion to strike issue, threatening sanctions. And then literally a few days later, we have this Rule 11 motion for sanctions. And so I don't know here's what I think is happening. I think that they suspect that the motions are going to be ruled on soon. And rather than making a pitch for oral sanctions, like at the hearing during oral arguments on the 12B6s, if they're going to do are they going to do oral arguments? Do we know? Have they scheduled those hearings yet? Oh, you're muted. You've muted yourself.
Sorry, I was just talking mad shit about you too. No,
I thought you were just being a dick, like pretending like I was deaf or something.
No, I was 100% serious. I forgot. No hearings have been set for that. Nothing. So since the hearing back in March, nothing has been set.
Yeah. Well, here's what I gather. I think that they're doing this because the totality of behavior on Friedman's side, from the Lively Party's perspective, has been particularly egregious, capped off by the extortion claim, allegation, stunt.
Right.
And so now we have impermissible group pleadings and all the arguments that you heard before that you were very bored with earlier. In addition to the stunts where Friedman basically accuses everybody of extortion. And they're saying, look, we've had enough of this. In addition to the 12B6, if you find that they have impermissibly group pled this stuff, which I don't think that they have, by the way, in addition to all the other conduct, I think that case law dictates that they should be sanctioned under Rule 11. That's what's going on. They're trying to get it in. I want to say premature is the right word. Now I have a better understanding procedurally what they're doing. I think that they're just setting it up so that the judge, if he's going to rule a certain way on the 12B6s, has it on his desk to also sanction them under Rule 11, given everything that's going on, because they're going to argue that the admonition for sanctions on the extortion allegations was for that specifically. Mm-hmm. But all of the other grounds for Rule 11 sanctions, we have in the aggregate one compelling case that they should be sanctioned, and they want it addressed at the oral arguments, and I think that's what we're doing.
Yeah. Can you explain what the group pleading thing means and why you don't think that's a problem?
Yes. So take, for example, Walmart or Amazon, the company. I don't know how many employees they have, but it's something like over 1 million. So if you sue the corporation Amazon, you're not really addressing everybody individually. You don't have an individual case against every single employee at Amazon. The Wayfarer parties, I think there's like 7 of them, last I checked, all have individual claims. And so it's not Wayfarer lodging a singular complaint for stuff. It's each of them individually lodging a complaint against all of them. They're trying to say that's impermissible group pleading. You can't do that. You're forcing us to defend against every single individual when it should just be one. And that's causing our cost to skyrocket, and it's causing us 7 times additional work when we could, 7 different sets of discovery when it could just be the one. That's what they mean by impermissible group pleading.
Yeah. Neidigh is saying that she also group pled her sexual harassment lawsuit. So.
Yeah, against the entire Wayfarer Corporation.
Right.
But the difference being, like, if you sue Amazon, you're not assuming that the janitor that works in Wichita, Kansas, I'm not picking on Wichita, Kansas, but would be involved in that claim. When you say the Wayfarer parties are Wayfarer, the company, and it has like 7 key players, you're necessarily accusing all of them.
Yeah. All right. Let's see. So let me go down through this a little bit. So I want to also talk, because that kind of covers a lot of what's going on here, because they're saying like this claim doesn't apply to blah, blah, blah. But also, hang on, let me see. I want to cover, they were saying that Friedman's comments in the press were an issue.
Yeah.
Okay, so how true is that? Like, how accurate do you think that is? Because there's all these block quotes of what he said in the press here about Blake.
What are they saying specifically about his quotes in the press? Because you're allowed to make PR statements. Right. There's nothing against running a PR campaign. So I need them to be specific. And by the way, this document that you're reading, I have not read, and so
I know. So these block quotes and all that stuff. So like he's saying in the press here, let's see. Her motion to dismiss herself from the self-concocted disaster she initiated is one of the most abhorrent examples of abusing our legal system. Is that going too far or no?
No. How's that any different than calling Justin Baldoni a sexual predator to anybody that will listen? That's
what I didn't understand. So I'm like, why are you basing a fucking motion?
I mean, if Friedman wanted to, he could, I'm sure, compile a list of all the quotes that they've made to the media.
He wouldn't have to, man. Like 70 people have it ready.
It's all right there. And so it's not any different. Like for me, there's nothing. He could have opinions about the way that they've represented themselves, and nothing that he's done has prejudiced the case. He's got an opinion. He believes in his clients, and he has statements. I don't think that any of this is impermissible. And even the judge stated that, look, you got a public case. Things are going to be said in the public that wouldn't normally be said. But that's the nature of what we're doing. Let's just keep it under wraps. And I think the reason why he struck the pleadings specifically was because we wanted to prevent, or the judge wanted to prevent, a situation where, because it's on the docket, he didn't want to make it like freewheeling permission to make potentially defamatory statements against the other side without evidence. And so he says, look, if you want to say that, then you're going to be bound to all of the laws, actionable causes of action that might come against you for saying that in the public. You're not just going to bury that in the docket and get away with that and have the media run away with. That's the reason why he struck that. So that statement by itself, just examine it. Lively's recent motion, scroll back up.
Yes, sorry about that.
Lively's recent motion to dismiss herself from the self-concocted disaster she initiated is one of the most abhorrent examples of abusing our legal system. Stringent rules are put into place. This is his opinion about her legal maneuvering. Laws are not meant to be twisted and curated. That's his opinion about how law should be conducted. As we said yesterday, in response to Mr. Reynolds' same cowardly measures, we will continue to hold Miss Lively accountable for her actions of pure malice. He's already pled that in the pleadings. And so there's nothing out of bounds by this. They've been saying the same stuff like throughout the whole thing in their pleadings and letters to the judge. And so I don't know why they're so bent out of shape by these block quotes. I'm thinking that it's just starting to get under their skin. That they are getting destroyed in the public, and they're sick of it, and they're trying to fight back as much as they can. like we talked about last week, they're litigating like they're losing the case.
Mhm.
And even if they're not losing the case on paper, they're certainly losing it in the eyes of the public, which means a great deal to these very public figures.
Mhm. So I know we're veering a little bit off here, but there was something I wanted to ask you about. You were gone when this came out. So Jed Wallace's amended complaint against Blake Lively in the Texas court. I want to talk about stuff that happened in the press or in the public that's being brought up in these pleadings. So there's a point here, and I asked, like, I think it was Rachel. I asked about this, and one of these she said this is stupid because that's what I thought, but like I wasn't really sure because obviously I'm not an attorney. So
Yeah.
let me change the tab here. So we're looking at 14 and 15. So this is Jed Wallace's complaint against Blake Lively, and I'm curious as to how this applies to defamation. Let's see. After this lawsuit on February 4th, after she sued Wallace and Street, Lively, accompanied by her publicist, appeared at South by Southwest. So this is Austin, Texas. She went there for a movie premiere, unrelated to this case. So it was another simple favor premiere, and they're noting here that she was confronted by a Texas resident who stated that Blake lies, and referenced justice for Justin. So that was Colonel Kurtz, another YouTuber who went there. She was a lone protester with a
Okay.
sign. It was like a rainbow glitter sign. It said Blake lies, justice for Justin or whatever. And I don't think Blake even. Yeah, no. She's cool though, but like I don't know how this falls into defamation because I don't know if Blake even saw that sign. Colonel Kurtz was kind of minding her business. As far as I know, she was peaceful. She didn't do anything, insane, and she never confronted Blake Lively and was like, "Hey, blah blah." You know what I mean? So it says here, Lively never admitted that her statements were false, but rather allowed her lies to stand, thus defaming plaintiffs by at the very least implication. So there's another one I want to go over directly after this, but as far as that goes, when we're talking about stuff that happens in the press and in the public, and we're bringing it into these pleadings, like, how does this apply? How does stuff like this apply? Like, when does it matter? Versus this seems to me like it shouldn't be a thing. Almost.
Well, when you say stuff publicly, I mean, I'm not sure if anything described in this paragraph is defamatory. I mean,
right. Because this is just like not confronting a protester.
Yeah, and I guess I'm trying to reason with this sentence. Lively never admitted that her statements were false, but rather allowed her lies to stand, thus defaming plaintiffs by, at the very least, implication on information and belief. While in Austin, Lively made additional defamatory remarks concerning plaintiffs. Discovery will reveal the extent of those statements, so we don't know what those statements are.
Right. Mm-hmm.
I guess I don't understand what they're getting at here. Like, where's the defamatory part?
That's where I'm getting confused too, because it was literally Colonel Kurtz was there with her sign and her shirt, and she was just like, she did some street interviews, but she never went up and confronted Blake and said, "Did you lie about this?" You know what I mean?
Yeah, that's not ridiculous. If they're saying that her silence and not addressing that sign is somehow defamatory by implication, that's a little ridiculous. It's a bit of a stretch.
Well, somebody's saying, so this is what my initial thought was the same as this person's right here. It says this wasn't for defamation, it's to establish jurisdiction in Texas. But in their paragraph right there, it specifically says defaming plaintiffs by implication. So they're saying it was in fact defamation.
Sure. Well, that just might be if it's that would make sense for jurisdictional grounds. Like, for example, if you're suing for promissory estoppel, for example, you may also sue for breach of contract, even though you can't prove the element of consideration because you're literally trying to sue for a broken promise of a gift. And so you may just throw in that additional, like, for example, this specific event, if it would be for a jurisdictional purpose or to preserve the argument, very clearly they admitted that, look, there's statements that were also defamatory that are going to be revealed in discovery. So they're just preserving the argument, basically.
Yeah, I guess I just feel like saying holding up a sign that says Blake lies is not really a defamatory statement towards Jed Wallace is my thing. Like,
is that what they're trying to say? I'm confused. I thought this was okay. So who's this supposed to be defamation against?
Jed Wallace and Street Relations Incorporated in Texas.
Jed Wallace.
So we're looking at his amended complaint against Blake Lively. Jed Wallace, the supposed shadow campaign master, who honestly I think that Blake and Jed don't. Neither one of them has a really great case against the other.
But
in
they're
my
stating
opinion,
that
but-
Lively committed defamation by not correcting this sign,
right, even though she probably didn't see it.
which is ridiculous. Yeah, it's ridiculous.
Okay.
So what they're saying is, look how ridiculous this argument is. So Lively, accompanied by her publicist, Leslie, appeared at this event in Austin.
Yeah.
She made additional false and defamatory remarks concerning plaintiffs.
Yeah.
Specifically, when confronted by a Texas resident.
But confronted by
sound,
is a huge stretch.
I agree, but notice how they are wording it. The jurisdictional argument makes sense to me. Confronted by a Texas resident who stated that Blake lies and referenced justice for Justin, I guess by a shirt, a glitter shirt or a sign or whatever you said.
It was a glitter sign. Okay.
I don't know. Lively never admitted that her statements were false, but rather allowed her lies to stand, thus defaming. We don't even know. We haven't even proven that they're lies yet.
Yeah.
So all of this is
Colonel
bullshit.
Kurtz was like Colonel Kurtz was just. She wasn't doing anything improper. She wasn't confronting Blake Lively directly. She wasn't, getting up in her face or anything like that. Like she was really just kind of doing her thing. Like I said, she conducted a couple street interviews, but that was about it. She was peaceful. She wasn't arguing with anybody. She didn't say anything obviously defamatory towards Jed Wallace or anything like that.
Let the record show that page 6, paragraph 14 of Jed Wallace's amended complaints, out of all of the defamation claims that I've seen, out of all of these pleadings, this is the weakest yet.
Mm-hmm.
Maybe it was just for jurisdictional purposes. I don't know.
I guess so. I guess that must be it because like I said, I don't understand this. So if it is jurisdictional, I guess 15 would also make sense because so do you remember hearing about Blake going to that hotel in Waco and allegedly fat shaming the girl?
I have not heard about this.
Okay, so she went to this hotel in Waco after South by Southwest, and a girl in the lobby sees her and she films her because she's like, oh, I saw a celebrity cool, I want to send it to my friends. And then this girl alleges that Blake then followed her at some point and filmed her back and was like upset about her filming her. And like there's a lot in between that's not verified, but that's what this paragraph 15 here is referring to. And so they're saying that it was defamatory that she did not correct this girl, I guess. I don't know. On information and belief, Lively made additional defamatory comments, purposefully availing herself of the Texas forum.
Yeah, but if you have, okay, it's like you have no duty to correct people. Like if people say stupid shit, it's not within your purview to go up to the crowd and say, hey, you guys are fucking idiots for the stupid shit that you're saying. You're wrong. And let me set the record straight. That's not how real life works.
Yeah. So somebody's asking. And so this was my question at first when I read this, because her response came out on Friday. This person says, do we think that he's making a case that Blake allegations have made it to Texas? I mean, maybe that makes sense to me, but like at the same time, it's like, why would you say this stuff about a confrontation that there was no actual, we don't have any proof of actual confrontation with the girl in the hotel. And we definitely don't have any proof of confrontation with the protester at the Austin thing.
Keep in mind, these complaints, especially if they're not verified complaints, and I sincerely doubt that this amended complaint is verified.
I don't remember. So
you throw whatever you think might be a thing at the wall on the chances that it might stick. I mean, granted, this is an amended complaint, but I don't know how much weight to put into the jurisdictional argument, but I'm not buying that it's an actionable cause.
Okay.
An actionable defamatory cause, because she may have fat shamed a girl. Is that the? I got to read this paragraph. During her
the thing with the girl, I'm gonna have to talk to you about this whole thing with the girl offline at some point, because it's a whole side quest, and it's.
How did I miss this? I feel like I was
Oh, this is when the angry Blake Lively Taylor Swift fans started really targeting on me, and they were like, "Oh my God, you're a heinous chin flaunting loser." So yeah, so this girl, like, she was staying in Waco, and like I said, she saw Blake walk into the hotel, took a video, but then she alleges that Blake, stalked her outside the hotel afterwards and tried to film her and was like kind of aggressive, and then all of a sudden Blake's lawyer and some other people start watching her Instagram stories and stuff like that. So I'm not sure what this has to do with Jed Wallace, other than it happened in Texas. So like we have a couple commenters here saying like maybe it's just to establish that this stuff has reached Texas or like whatever. But at the same time, I'm like, I don't really get it.
I mean, the lawsuit's already in Texas. They don't need to establish that. I mean,
Well, I think they're arguing over jurisdiction. So,
my understanding was that well, I don't know if they're settled on the Texas issue, but they have jurisdiction in Texas on other jurisdictional grounds. Like they don't need this defamation claim to have taken place per se in Texas. Maybe I'm misremembering. All I know is from what I remember, you got to be pretty specific about what defamatory statements were made. That's what we've learned.
This is very vague as well.
Yeah,
so
and I don't even know how anybody was defamed by reading just the words of this paragraph. A young girl who was attempting to take Lively's photograph. Lively makes additional defamatory comments. They don't name what they are. Purposely availing herself of the Texas forum. That's a jurisdictional sentence. Discovery will reveal the extent of those remarks. You still got to give an offer of proof about where you thought it was going.
Right.
Is it in paragraph 16 or are they moving on to something else?
No.
Yeah, it's really vague. It's not gonna stand. It's yeah, there's I understand the confusion.
Yeah, I'm very, very confused about that. And then the reason I wanted to bring that up, I know that was kind of like I said, a side quest, but the reason I wanted to bring that up is because so much of stuff that's being said in the press is being brought up here. So then when I saw that thing about the protester, when I saw the thing about the girl in the hotel, it's just kind of like, well, a lot of stuff that's happening not related to what happened on the set of it, it ends with us, is being brought into these complaints, and I'm just kind of like, damn, like this is getting a little nutty in my opinion, but I've never seen anything like this. I never followed Johnny Depp, Amber Heard. I never saw anything like this. So I don't know how much is normal and how much is not. So
I'll tell you what. I know you've never been involved in like these lawsuits that have like a dozen different parties on both sides, but you have a lot of side quests in here, but the case usually boils down to the main parties. Who's the main parties in this case? It's the Wayfarer parties, it's the Lively parties, it's Lively versus Baldoni. That's the main event with these cases. When those two settle, everybody else will fall in place. And I suspect that this Jed Wallace complaint will also go away once they drop the complaints against him. And nobody's after him. They're after him because
they're after him, I guess.
I mean, they're after him, but like if they get an acceptable settlement from Baldoni, they're not going to keep pressing on him.
I don't see that happening.
Yeah, like it will be settled.
Why would Baldoni settle at this point? Unless they gave like a full retraction. So like he wouldn't settle unless it came out his way, I guess is my point. Because a lot of people say that it's like because of Hollywood and the industry, he needs to clear his name and stuff like that. But also what a lot of people don't realize is like his religious beliefs, his spiritual beliefs are something that's very important to him. And they have a very strong sense of kind of justice and, independent investigations into the truth and stuff like that. So it's very important to them to get to the truth of the matter. And so they're not just going to like give in to money. They're not just going to be like, okay, you give us enough money, we'll go away. No, these guys want a full retraction. They want a statement that says, you know what, we were wrong. Otherwise, they're not going away. And so Jed Wallace is kind of caught up in this, in that he wasn't even mentioned in the first complaint.
No, I know. Well, I thought they did mention him, but like kind of cursory.
No,
not at all.
They didn't mention him at all in the first complaint. In the lawsuit, they did not mention him.
They mentioned him.
They mentioned him in the CRD. And then they did not mention him in the lawsuit. Then he decides to sue them for defamation for putting all this shit about him in the New York Times, but not mentioning him in the lawsuit because they knew they didn't have any evidence that he did anything wrong. And then after he sues Blake Lively in Texas, Blake Lively then adds him to the New York lawsuit.
When I did my role play with Neidigh, I got her to give me $600 million for Justin Baldoni.
No fucking wait, what?
She was gonna give me $600 million in a public apology, and I advised my client to accept that offer.
Mm-hmm. Yeah.
She straight up said, "Everybody's got a price." That's what she kept on saying.
I'm gonna say this. Again, I disagree that everybody has a price. These people that we're talking about, like these Wayfarer people, that they're all very strong in their faith and their belief that justice and truth are more important than money. I do not see them settling at all for any massive sum of money unless there is a truthful apology or retraction attached to that. I don't.
Well,
see
let's have that philosophical
Philo, what the fuck?
Let's have, okay. I got to tell you, do you know how many clients have come to me over the last 11 years, all of them stating, you know what, it's not about the money for me. At the end of litigation, for very infinitely less amounts of money than is being litigated here, it's almost always about the money. And if it's not, well, I'll retract that. It's not about the money at first.
Hang on. Let me say right now, stop you right there.
Okay.
And I'm gonna let you finish, obviously, but I'm willing to stake my fucking reputation. They will not settle without a retraction. It's not going to happen. They don't care about the money that much.
Oh, they'll do that.
These people, they will not do it. I'm saying right now, like, they will not do it. I'll stake my reputation.
I agree with you on that. I think Baldoni just wants her to say she's sorry. I think he would be cool with that. I agree.
He'd probably take $3 in apology. That's the kind of people we're looking at here, and it's so sad because it's like these assholes are dragging him through the mud as much as possible before it ultimately comes to that conclusion, I think.
But that's
instead of a jury or not. So
yeah, no, I mean, I agree with that. But at the same time, I'm just pointing out that after a while, it sucks to be in litigation, man. I mean, when you were having your spats with Gingerbread, you weren't even in litigation. Like,
I forgot he existed for a second. Thank you.
I know, but the anxiety of just like even the mere threats of it was like causing you great stress and anxiety.
But I had you, so I was fine.
Yeah, I mean, but before that, you were like, "Oh, I don't know what to do," and I'm like, "Lauren, don't worry about
3 seconds before that."
I'm just saying, imagine being in that every single day for months, going into years. I mean, it weighs on folks to the point where it's like, you know what? The last time this happened, I had a client that was standing on business. We were at a civil lawsuit, and they're like, my client was being sued. And unfortunately, there wasn't a countersuit. So it was literally just they were going to be on the hook for what they were asking for. I think they're asking for like a couple $100,000. At the end of it, I got it down to where they would have settled for like $1,800 or something like that, some ridiculously small number. When if they were going to go to trial, they were going to have to pay me an additional retainer of $25,000 to litigate the trial. And in the hopes that we might be able to recover their attorney fees and costs, or they could just pay $1,800 now and be done with the whole thing. And they're like, no,
greedy bastard.
Yeah. But they stood on business, man. They stood on business. It turns out when we did that, we walked away from the settlement. The very next day, that case was settled for $0. Case was dismissed. So sometimes you're right. It is not about the money. In the case of Baldoni, however, in my role play, I just want to point out, if I was getting $600 million from Neidigh, and she was more ruthless than I think she was trying to go. She was asking for like a cool $1 billion. I will take $1 billion in a public apology, and you will declare that I am.
Man, I'll just give Neidigh what she wants. Just take it. It's fine. Just take it. That woman's an encyclopedia, man.
Yes, she is. You don't want to play Jeopardy with that young lady.
Oh, fuck that. I'll just watch.
Gross, Lauren.
Oh, come on, dude. I'm not talking about me and your dad here. Yeah, no, so I don't know. You know, think about wait, hold on. What the hell? Don't invite you. I'm sorry. I was reading other text messages from somebody else. I don't know what they were talking about. I'll deal with it later. Anyways, so these, accusations and stuff like that, I feel like I said, I don't feel like there's really a price on them for the other side of this lawsuit. I don't think that Justin would really settle for anything, or Justin and his, team or whatever would really settle for anything less than a retraction. I also feel like, okay, let me put it this way. You know me, I feel like pretty well at this point.
Yeah.
And I feel like you've probably seen me kind of give people the benefit of the doubt where I shouldn't.
At your peril.
Right, exactly. And so I'm the type of person who is always, always, always going to give the benefit of the doubt. I'm always going to see the best of people. I'm always going to, you know, think maybe there's more to the story here. And I'm telling people, and I can't, there's more that I can't say right now. Someday I will, but there's more that I can't say right now to where I'm like, I promise you, this man is the real deal. They try to make him out to be some kind of cringy fake feminist. No, this guy is the real deal. His family's the real deal. His company, Wayfarer, is the real deal. Like these are the best people. It might not seem like it. They might not be the most famous. They might not make the most money. But what I've come to know behind the scenes is undeniable, and I believe in them to the very end of this, no matter what happens. So
What does it say
I
about human nature that they can't look at something like Justin Baldoni and just accept that he might just be
well,
a
it's sad.
genuine good guy? You
It's
know,
sad, but I get it. Like I said, as somebody who always tries to see the best in people and always tries to see reason and always tries to see the other side, I can see why people are looking at that and they're pointing the finger and they're being like, "This is no, there's no way this is real. This is cringy. This is
I
fake.
know
He's
why that is.
creepy." But it's not
Even
true. Like it's not true this time. This one time, this man is so for real. Please
well,
don't ruin him.
you
Like,
should
please do not
understand.
ruin this man. Please do not ruin this man's family. Like, he deserves so much better than that. And I'll be so sad if it doesn't work out in some way for him. So,
I believe that he's a good guy, but at the same time, the world knows that people like Gandhi exist,
yeah.
and even that effing guy had mistresses and did nefarious things that came out after the fact, and that people had to cover up. And so it's not that I think that people see somebody that represents the things that Justin represents, and they look for the cracks and the holes. And when they find one, they try to bust it open. That's what's happening with Justin. It's no different with him. It was no different with every person that is trying to take a stance for good in the world. And it's going to be no different 50 years from now when I'm long dead and buried. It's
50
just
years from now,
human
dude, you're
nature.
not that old. You're going to make it. You're going to
I
make it at least
mean, all
51
right,
more
100 years
years.
then.
Okay.
I
100
don't know
years
if I
might be a
want
bit
to
of a
make it
stretch,
another
but
50. 50 years is a long time, man. That will be
Hmm.
94.
Oh, Omar, you're getting a raid from MG Law.
Oh, nice. What's up, MG Law? MG Law, folks.
All right, let's see. So we went through this memorandum regarding the sanction motion and stuff like that. We went over that Chad Wallace stuff regarding the PR, not PR stunts, but the PR aspects where I felt like we looked at the protest and the hotel thing. So now we need to get to this. Hold on, let's see. The motion to compel, and this is not the same as the motion to compel we talked about last week, which was just a
Right,
motion
I know it's
for
a little different.
compelling the financial info. So this is talking about an investigation into her sexual harassment claims that was started by Wayfarer Studios after she made her CCRD complaint. So when she had them sign that 17 points return to production demands or whatever, she said, basically sign this or I won't continue to do the movie. I won't promote it and stuff like that. But if you sign it, then I'll keep doing the movie, and also I will forego a formal investigation. I will forego a formal HR process. So that's important to keep in mind as we read this document here.
Okay.
So this here, let's see. This so-called investigation is and this is Lively's attorneys. This so-called investigation is a disingenuous charade. Wayfarer failed, although it was legally required to investigate Miss Lively's concerns when she first raised them in May 2023. But the thing is, like I just said, the 17-point return to productions document and everything that preceded that, it was all do what I want, and I won't file a sexual harassment claim. I won't do
Right.
an official complaint. I won't ask for an investigation. So now
Closer to
she's
extortion.
saying, yeah, she's upset about this investigation. They're trying to stop it, and they're saying basically that this investigation was paid for by Wayfarer. It's influenced by Wayfarer. It's tainting witnesses in the lawsuit. You don't have a right to do this investigation right now. It's not neutral. They're conducting one-sided interviews, all kinds of stuff like that. I don't know the ins and outs of like normal workplace investigations, but is it a problem that they're doing this at the same time that the lawsuits are going on?
I mean, it's not a problem. Why?
They're saying
You
it's a
have.
problem. So
You can have multiple investigations going on at the same time. That's not ever been illegal. You know, criminal investigations, civil investigations, administrative investigations, which is what the CRD would represent. She doesn't want it to happen, you know, she has her reasons. She doesn't like, I guess, that Wayfarer is trying to ensure that what does this letter say? So she's saying Miss Lively would have participated in such an investigation.
Hold on. I feel like a lot of people probably haven't seen this. You want to do me a favor and like start reading from
Yes,
here?
ma'am.
And I'll be right back. I just have to get some more water.
All right. This so-called investigation is a disingenuous charade. Wayfarer failed, although it was legally required, to investigate Miss Lively's concerns when she first raised them in May of 23. Had it done so, Miss Lively would have participated in such an investigation, and it would have substantiated the sexual harassment she suffered while on the set of the film It Ends With Us, which included, among other things, Mr. Baldoni's unsolicited discussions about his addiction to pornography and sex life and his improvised intimacy scenes without Miss Lively's consent. If her complaints were promptly investigated as the law requires, she may also have been spared the retaliatory smear campaign by Wayfarer and its co-defendants. Instead, Wayfarer waited years until late January 25 to initiate this investigation. By that time, Wayfarer had already forcefully publicly denied Miss Lively's allegations and sued her and several others for $400 million for making the very same allegations that are now the subject of this neutral investigation for a workplace that no longer exists, the film set. What's more, by January, its counsel had repeatedly called Miss Lively a liar in widely circulated media interviews. Under the guise of the investigation's neutrality, Wayfarer is conducting one-sided interviews of unsuspecting third parties, potentially tainting the ongoing litigation, while reserving for itself the option of whether it will release its findings or bury them behind a cloak of attorney-client privilege. Meanwhile, the investigation has dragged on for nearly 5 months, conveniently providing a pretextual basis for Wayfarer to refuse to produce otherwise patently discoverable information, particularly given Wayfarer's publicly stated foregone conclusion that Miss Lively's allegations are not true. Wayfarer is not permitted to wield the attorney-client privilege as a sword and a shield, invoking the privilege for now, but insisting that it may waive it later at some unknown future date, presumably if and only if the investigation yields a result Wayfarer likes, which it will no doubt publicly release with much fanfare. The motive is clear. Wayfarer hopes to conduct shadow fact discovery under the pretext of an attorney investigation to prevent Miss Lively from obtaining critical information until it is too late. Wayfarer's refusal to confirm its position on the attorney-client privilege is improper. Moreover, regardless of whether Wayfarer intends to rely on the investigation at trial, its choice to initiate the investigation in the middle of contentious litigation years after the events at issue first arose means that it must disclose the underlying materials now during discovery. I kind of agree with them on this. If they're gaining investigative materials into the subject matter of the case, they should be entitled to receive the contents of that investigation. Like, what's the point in hiding it?
Okay. Well, let's skip. Hang on. Let me skip ahead then, because that's one way to look at it, and that makes sense to me, right? So,
but here's the thing too. It's like so they're calling it a neutral investigation, but they're correctly pointing out that look, they're the ones that are saying that Lively is a liar, but they're only going to disclose it. I'm sure if they find this to be dispositive of Baldoni's case, I'm sure they're going to release it to great fanfare. So does that mean that they're not going to release it if they find out that it's inculpatory of Baldoni? Maybe it proves something that Wayfarer did that was wrong that they don't know about. That's bullshit. We're litigating a case. This is an investigation. They can't hide behind. In other words, you're not allowed to just conduct an investigation and it produces exculpatory evidence of our clients, but you're claiming that you don't have to disclose it because of attorney-client privilege. That's seems like bullshit to me.
So we're gonna keep reading, obviously, because there's a lot more to go here.
I
Because
got to read the
there's
rest of this.
correspondence. Yeah, there's correspondence between the two, but we don't have to read this exact part. But
Oh, is there nothing?
Anita also wants you to know that they are investigating if there was an HR complaint in the first place. Also important to realize, which which we get to down here.
I could
Is
feel
that
Entity's energy from all the way over here. She gets so upset. She's like, no, they're investigating whether or not there was even an HR complaint. Do you need to know that?
well,
I could already hear her yelling in my ear.
I get the passion, dude. Because so here's the thing. They gave her an opportunity. They gave Blake and the I think Blake's counsel probably could have been present because it says that counsel could be present. An opportunity to be there and to be interviewed, and as well to add people to the witness list that she thought should be present. She thought should be interviewed because they had relevant information, and they basically refused.
Yeah.
And so hang on, let's see. So that is this is on behalf of our client Blake Lively. So we're gonna get to the first, the fact that your firm has only been retained now, nearly 2 years after Miss Lively's first raised her harassment complaints. So again, the 17-point list was not a harassment complaint.
Who's this letter
Second,
addressed to?
to the firm that's doing the independent investigation.
Okay.
So they hired that neutral.
I think you need to read this letter because I've not seen this before. Scroll.
You want
all
to read
way
the whole
up.
thing? Yeah, go
I
ahead.
want to read the whole thing.
All right, let's do it.
All right. First, this is Valentine's Day of 25.
Hot.
The fact that your firm has only been retained now nearly 2 years after Miss Lively's first raised her harassment complaints in 23 makes a mockery of the law's requirement of a prompt investigation. I guess the retort to that was, well, we did investigate and there was nothing. There wasn't even an HR complaint. There's reasons for that. Anyway, I'm assuming, but what a way to start a letter. The most significant meeting. As the EEOC has noted, even a 2-month delay in investigating fails to meet the statutory requirement of prompt investigation. When we spoke, you had no explanation for Wayfarer's nearly 2-year delay. And indeed, you stated that this delay was one of the issues you're going to investigate. The fact that Wayfarer has only now decided to investigate Miss Lively's claims irrefutably proves it has violated its obligations under California. No, I think that the point is, if there was an HR complaint, no doubt.
There was no HR complaint.
It's unequivocal that they would have, if there was an HR complaint, 100%, they would have had to investigate that to its conclusion. Mm-hmm. If there was no HR complaint, then that would explain why there was never an investigation. And now you filed a lawsuit. We need to figure out, number one, I guess like Anita just said, maybe one of the things they're investigating is, did she make an HR complaint?
She did not, because Sony's come out and said no, she did not make a complaint to Sony. She did not make a complaint to her union like she was, required to do in those circumstances. And she did not actually make a formal HR complaint to Wayfarer. She was like, sign this and I won't do this shit.
So then here's my question then, as an attorney. If you know that your client didn't make an HR complaint, why would you be trying to compel the results of that investigation if it's not going to help your client? Conversely, if
what they're primarily trying to do here, which we haven't got to yet, they're trying to they sent them a cease and desist. They're trying to stop the investigation.
I know, but my point is, if one of the things that is going to come out in the investigation was that there was an HR complaint way back in 23 that was properly filed, that was required under California code to be investigated, and it was not, would that not be dispositive of that cause of action? Like by statute? Wouldn't that be like grounds for a motion for summary judgment even? That one of her causes of action was that Wayfarer failed to investigate, as they were statutorily bound to do, an HR complaint that raised the ire of SH.
Right.
So if the investigation would reveal that, why would they be trying to compel that if they know that Lively didn't make that complaint? Either they know that Lively did make that complaint and they want it to be exposed or come out, or I don't know why else they would be doing that, honestly.
So they should want the investigation. Is that what we're saying?
They're trying to compel the results of the investigation, correct? That's like the nature of this.
They want the recordings from the witness interviews because the investigation is ongoing still.
Okay, but so is it limited only to those interviews from potential witnesses?
It seems that way. Hang on, let's look at the top. Let's see. So they're compelling. Hold on. Documents and witness recordings concerning Wayfarer's purported neutral workplace investigation. So they just want to know
Right.
what was said. Okay.
So then, to me, that would include the initial HR complaint.
Okay.
So they want that because either they know that Lively did file a complaint.
No.
I know you're saying no, but my
refuse.
question is, if the investigation reveals, see, here's what's blowing my mind. Like, if the investigation reveals that she actually did make a formal complaint, and here it was, it was even stamped and it was received, and they just never complained, then that would be like the smoking gun evidence where they're going to win on that cause of action. That's why I would guess that they would win.
They're trying to pass off this 17-point document as the complaint.
No, that's not the same as that was
It's
a letter.
Not the same. That's the problem.
It's not the equivalent. Bro. That can't be the reason why. It cannot. It cannot.
It cannot, but they're going to try to force it down our throats.
Oh, they can kiss my ass with all of that. That's just not what that was. I read it too.
Your ass is going to be chafed then.
Jesus. All right. I'm just saying, man, it doesn't make any sense why they're compelling. They want the results of the investigation if they don't think it's going to help Lively. So that tells me a little
bit stupid in my opinion, but that's
okay. Well, look, here's my thing. Here's how the conversation might go if you were Blake. We're going to role play.
Well, this is a one-sided conversation. I can already tell you that, but go ahead.
Blake.
Wait. Who's Blake? Are you Blake?
You were Blake.
No. Fuck that.
No, you have to be for the purposes of this conversation.
I hate you, but fine.
I need to know right now, did you file an HR complaint or not?
Sorry, I have goop in my hair.
Goop?
I totally did, and my husband and my other dragon were there when I forced people to sign it.
When you filed your complaint, who did you make the complaint to?
People in my penthouse.
Did you go to the HR department and make a formal complaint for SH?
No.
Well, then that was the wrong answer. God,
that was the true answer. That's the truth, bro.
I'm willing to bet that she said, yes, I did. And so much like, sometimes you got clients.
I was too honest. I told you I can't play the weird blonde chick in this scenario.
I'm just willing to bet that Lively has convinced her attorneys that she actually made a formal HR complaint. Or she might have. I know that in her amended, she says that, I went to this place to try to make an HR complaint, but I was turned away because I wasn't in the right place. And so they told me where to go and I just never went. That's kind of how her went in her amended.
No. Miss High Heels and Special Hairspray knows where to go to make a formal HR complaint. Okay. You don't look at that woman and think, that's not a Karen who knows where to go to complain to the manager. Fuck that. All right. She knows exactly what she's doing, and so does her stupid ass husband. So don't even tell me that. They know the proper place is not in their penthouse. Okay? I cannot argue this anymore.
All right, fair enough. I'm just saying that her attorneys think that there's something that's going to help Lively's case in that investigation. That's why they're filing this motion. That's all. That's all. That is all. My only points. You're a terrible role player. Jesus.
I've lost my shit, bro. It's 1 a.m. What do you expect?
Well, that went well.
Anita says, I'll be Blake. Lauren can be Jennifer, Abel, and Cunt right and left. I love Anita. All right. Anyways, where were we before I started shouting?
I don't know, man. Okay. So their second point was an investigation must be thorough. As you know, the misconduct Wayfarer now claims it wants to investigate is the subject of multiple federal lawsuits involving multiple parties and dozens of witnesses nationwide, very few of whom are current Wayfarer employees. Any thorough investigation must entail speaking to all of these witnesses and reviewing any relevant documents and information they possess. However, when you spoke, you acknowledged that you have no authority to compel anyone to speak to you, and that you would be relying on Wayfarer, led by the very people who are the accused parties, to provide your documents and to set the scope and budget of the investigation. Further, Miss Lively alleged that the retaliation campaign perpetrated by Wayfarer and others against her was designed to be untraceable, but you could not explain how you would be able to investigate these allegations given the limits placed on your authority, including a lack of subpoena or other discovery power. Needless, okay, I see what they're doing.
Okay.
So they have it on good authority that they have very limited resources to convict, to affect any kind of investigation. So whatever investigation that they're doing is not going to be thorough. It's going to be this cursory thing, meaning they think that it's not going to be enough, and they're going to be able to point to the lack of thoroughness of the investigation, and that by itself is going to help Lively. Now it sort of makes sense. So they know that it's not going to turn up anything, and when it turns out that, oh yeah, we did a whole investigation and there was no HR complaint, they're going to say, well, did you look here? Did you look there? Did you look everywhere? No. Well, why not? Because we didn't have the resources. Well, then who put you in charge of the investigation? Should you have been the persons doing the investigation? Weren't you? Isn't that kind of a conflict of interest? Weren't you the ones being accused of not investigating in the first place? So they're trying to get this so that they can get the breadth of lack, or the lack of breadth of investigative powers by this party conducting the investigation. That makes more sense to me than the HR complaint thing. All right. Third, an investigation must be effective, designed to lead to remedial action to stop the harassment. You told me your role would be one of fact gathering, and that you were not charged by Wayfarer to make any recommendations or suggest corrective action. As a matter of law, this is not an effective investigation. On our call, you acknowledged that if these incidents occurred as alleged, there are significant problems within the organization that they will have to contend with. We, of course, agree. But rather than recommend remedial action, you told me that any report you might issue at the conclusion of your... Yeah, we're waiting on you, Lauren. The
Sorry,
power of the scroll.
Your Majesty, you didn't ask me to scroll.
This just tells me that you were not following along.
No, I was not.
All right. Investigation to decide what to do further. You told me that it would be up to Wayfarer whether to release any report or to bury it under a claim of attorney-client privilege. Wayfarer and his counsel have spent the past few months in the press calling Miss Lively the liar, stating that, okay, this is more whining against the backdrop of stuff, unfortunately, stuff. All right, I get what they're doing. I get it.
Hold on. We're going to move on to the next letter here. So this was a response to that on February 17th. This is 3 days later. And I have to pee and also listen to a voice message from Neidigh, which people are yelling at me about. So I'll be right back.
Okay. We received your letter of February 14th declining Miss Lively's participation in the investigation of her claims against Justin Baldoni, Jamie Heath, Steven Sarowitz, and Wayfarer Studios. While we acknowledge and respect your concerns, certain aspects of your letter mischaracterize our role, statements, and the fundamental nature of workplace investigations. Wayfarer retained our firm to investigate the claims made in Miss Lively's recent legal filings before the California Civil Rights Division and the United States District Court, Southern District of New York. Your client contends that the allegations surfaced years ago and should have been investigated. The scope of our investigation includes whether Miss Lively filed complaints and whether Wayfarer failed to investigate them. We will determine through this investigation whether a preponderance of the evidence supports her claims. Even if Wayfarer failed to investigate Miss Lively's prior complaints, as she alleged, Wayfarer still must investigate subsequently filed complaints, regardless of timing. Once serious allegations come to light, a neutral investigation remains a necessary and appropriate step, and we intend to carry out that obligation in accordance with best practices. You expressed concerns regarding the scope of the investigation. Wayfarer's payment of our fees and the absence of subpoena power. While Wayfarer retained us, the core function of an independent workplace investigation is neutrality. Wayfarer does not dictate our investigation, nor determine who we interview. We pursue all relevant facts, including information from witnesses identified by any involved party. Your assertion that Wayfarer will determine who we interview mischaracterizes our process. As neutral third-party investigators, we rely on voluntary witness participation. This limitation is not unique to this situation, nor reflects a deficiency in the investigative process. It is simply how we do business at the airports. And so it seems to me that this independent firm hired to do the investigation, I don't understand. I guess I just don't understand why they are claiming, why they wouldn't just forward their findings to everybody. I get that, well, I guess the Wayfarer is saying this. We hired this firm. They're going to conduct an investigation. The results of their investigation, because we used our own resources to investigate the firm, is our attorney work product. If you want to conduct your own investigation, conduct your own investigation, hire your own firm to do your own investigation, then you can fuck off with, what is that? Did you just
Sorry,
fuck
bro.
it?
That was the ocean sounds. My bad.
Jesus Christ. What is wrong with you?
What's wrong with you?
I was just stating
You
that.
don't want to get into what's wrong with me, man.
Oh, there's nothing wrong with Lauren Neidigh. I lost my train of thought. Basically, what they're saying, what Wayfarer is saying is, so this firm is responding that, look, we're going to conduct a thorough investigation. Nobody is telling us what to investigate. We are looking into questions that might help your case. It is completely fair and above board. We were hired by Wayfarer. They are the ones that are categorizing it as attorney work product because it is the product of their resources. They do not have to give the results of their investigation, their independent investigation, to you.
The people are hearing what you're saying and they're telling you to keep reading. So I don't know what you're saying, but apparently it gets answered.
Oh, well, then I'll just shut the fuck up and read. How about that?
I mean, I'm cool with that, but I don't know what you were talking about. So
I was making sense of it in my head. Okay, so unlike litigation, workplace investigations do not afford subpoena power or other coercive measures to compel testimony. Instead, the process is designed to obtain information. Current company employees are typically required to cooperate per company policy, but external witnesses, such as former employees or third parties, may choose whether to participate. We make diligent efforts to identify and interview relevant witnesses, follow up with those who may initially be reluctant, and document any individuals who decline to participate. If a witness refuses to engage, that does not mean the investigation is ineffective. Rather, it is a reality inherent in this fact-finding process. To suggest otherwise would be to hold us to an impossible standard that is not aligned with how neutral workplace investigations operate. Your letter appears to frame these procedural realities as flaws. But in doing so, it creates a paradox. You acknowledge our role as independent investigators, yet simultaneously critique us for not having powers that no independent workplace investigator possesses. It is important to recognize that our role is not to compel participation, but to pursue the facts as thoroughly as possible within the framework of an impartial workplace investigation. We welcome information from all sources, including your client, and encourage the identification of any relevant documents or witnesses who may contribute to a complete and accurate assessment of the facts.
Oh, I brought in some backup, man.
How you doing, young lady?
Hi, I'm good. How are you? Welcome back.
I could hear you yelling at me all the way from across the Pacific.
I was.
Oh my god!
Thank you for listening.
Oh, I don't know if you're trying to text me or not, but my camera is my phone, and so
I have given up on that. That's why I was go for Lauren.
That's a good call, man. Good call.
Oh,
All right. We're
but anyway, what do you have to add to all of this?
I'm just you guys you can finish it. I don't want to like.
Sure, I'll finish the thing.
Yeah. I think
You
the
were, like,
end of the
right
letter
here.
is the best part.
Yeah. So damn it, Lauren, despite your client's decision not to participate, we remain open to receiving any information, documents, witnesses, stuff. Our objective remains to determine facts. So you have also raised concerns that an interview conducted in the presence of company counsel can never be truly neutral. As we discussed during our call, while counsel is always permitted to be present, particularly when legally required in the case of represented parties, their role is strictly observational, not participatory. If counsel, whether for Wayfarer, Miss Lively, or any other third-party witness, oversteps that boundary and attempts to interface with the neutrality of the interview process, we document that in our report and take appropriate corrective measures to ensure that such conduct does not interfere with the integrity of the investigation. Your letter also raises concerns about our ability to investigate alleged practices that may have been designed to be untraceable. As we explained, we understand the nature of the allegations and will take appropriate measures, including working with third-party professionals. The expectation that we should, at the outset, outline all specific investigative methods we will employ is unrealistic, and I agree with that. The nature of workplace investigations requires adaptability, methods evolve, and stuff. You state that our investigation cannot be effective because we do not issue recommendations. This reflects a misunderstanding of our role. We aim to determine facts and identify concerns, not implement workplace changes or dictate corrective actions. What the company ultimately does with our findings is beyond our scope, but identifying and documenting issues is the first step in addressing workplace concerns. Holding us responsible for implementing changes would fundamentally alter the role of a neutral fact finder. To state the obvious, if our investigation results in documented findings of harassment or other improper workplace conduct, and the employer fails to take appropriate remedial measures, they will undoubtedly face the consequences both legally and reputationally. This is particularly true in this case, where any actions taken will be subject to heightened scrutiny. The employer ignores substantiated findings at its own risk, as failing to act on investigative conclusions could lead to liability, regulatory scrutiny, and significant reputational harm. That reality underscores why independent investigations are critical to responsible workplace management. Wayfarer's decision on whether and how to act on our findings is separate from our function as investigators. However, the notion that our work is ineffective simply because we do not dictate this next steps mischaracterizes the purpose of an independent investigation. Our findings serve as a foundation for informed decision-making, and any suggestion that they can be disregarded without consequence is unrealistic.
All right, hold on. We're going to move down to the last letter, but do you have any thoughts on what we just read?
No, it's all pretty common sense, but I feel like the last part of it was like the most important part.
Well, it's all going to be in this one. Hang on.
Oh, okay.
Dear Miss Hudson. Yeah, right there. So we'll start right there.
Oh, they're writing this to Ezra?
Yeah, well, I mean, it's the last part of the back and forth. So.
Oh, all right. So we have now had a chance to review your letter dated March 28th, and then you demanded that we immediately cease our independent investigation of Blake Lively's complaint against Wayfarer Studios. You further demanded that we identify every individual contacted and turn over all our notes, communications, recordings related to those interviews under threat of court intervention and sanctions. That demand is baseless, procedurally improper, substantively indefensible, and experienced employment counsel. You are undoubtedly aware that the approach we have taken reflects not only legal compliance, but standard workplace investigation practices. Your letter reflects a willful mischaracterization of our role and the protections afforded to such investigations. Your letter appears designed to obstruct a lawful process and chill the participation of witnesses who might otherwise assist in a fair, impartial, fact-finding endeavor. To reiterate what we told you on our February 12th call and again in our February 17th correspondence, we are not litigation counsel to Wayfarer and do not operate under any litigation or public relations strategy. This is not an adversarial role, and we conduct our work free from external pressures, including those arising from pending litigation. Your assertion that we are conducting an illegitimate investigation or that we have been bought and paid for is disingenuous. The investigation is timely. As soon as Wayfarer learned of Ms. Lively's December 24 complaint to the CRD, Wayfarer immediately took steps to retain our respective firms to initiate and conduct a neutral workplace investigation to investigate any unresolved claims. As you are well aware, Wayfarer has the absolute right to conduct this type of workplace investigation. Your claim that our investigation is a sham designed to interfere with litigation is equally baseless. If taken seriously, your position would effectively nullify the entire purpose of workplace investigations. To suggest that an employer loses its right and ability to investigate claims of misconduct merely because a lawsuit has been filed is unsupported by any legal authority. To the contrary, courts have repeatedly affirmed that the pendency of litigation does not extinguish an employer's duty to investigate, nor does it negate the employer's right to gather relevant facts from willing witnesses, provided those efforts comply with applicable ethical and legal standards. Your allegation that we have misrepresented ourselves to witnesses is not only factually inaccurate, it is reckless. They're going to keep on going with more. Is there like, is there more? Is there going to be more of this? Because I feel like I get the point. You've muted yourself, Lauren.
Lucky you, man. No, yeah, it's pretty much the same. It's your claims regarding privilege are misplaced.
All right.
And then investigations conducted by outside counsel are routinely protected. Let's see. Even if they were to waive attorney-client privilege, that would not and could not compel the production of attorney work products. Let's see. The notion that witness interviews may only occur through adversarial depositions is not supported by law. Let's see. And then let's read this last.
We see no legal basis for ceasing an investigation authorized by federal and state law, and we have no intention of doing so absent a court order. We're going to continue to conduct ourselves in accordance with standard practices and our legal and ethical obligations as court officers. Moreover, we hereby demand that you discontinue making false and meritless assertions and reserve all rights, remedies, and privileges. Your cease and desist letter constitutes unlawful interference with an ongoing investigation and is plainly meant to try to intimidate, and you could shove it up your ass. Finally, we understand that you have asked us to accept service of subpoenas directed to members of the investigative team. We do not believe these subpoenas are appropriate or enforceable given the legal protections discussed above. But in any event, we will not be accepting service. And once again, you have permission to kiss my ass. We remain committed to conducting this investigation with the independence, professionalism, and integrity that it requires and that the law demands.
All right. So I want to invite you to keep your ass away from me, Omar.
Well,
but I want to unleash Anita a little bit here because she had a lot to say, and I was
Thank you.
I was gonna play your recording because I was like, I can't put it so well, but then I was like, you know what? I better just put her in here.
Thank you.
So, let me just take a back seat.
All right. Let me stretch. Okay, just kidding. But so the HR complaints, I just want to give the factual thing about HR complaints and proof how she did it intentionally not to have formal HR complaint. First of all, on May 25th, when she found about the COVID thing and then she withdrew from the set, blah, 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 she called Angie from Sony, and Sony even asked Lively if she wanted any formal action regarding her remarks. Lively responded that she was not interested in pursuing anything formally. That's stated out. So that's one. And before she left, this is the part, she left after Baldoni said no to giving access to dailies. And when the strike happened and when strike resumed, she did not come back. And she was sending X's and O's to Baldoni all that time, apparently, harassed on set. In August, she asked again for access to dailies. She was said no. And third time, she asked through her agent, and even her agent got a no from Jamie Heath. And all of a sudden, November 8th, when Jamie Heath, the last day of the strike, which would have addressed her concerns, that's when Jamie sends the information of the how the production will resume. That's when they send. That's one. The list of 17 demands, if you go through the list one by one, there is absolutely no indication that anything that she wanted in the list that had previously happened. All of if you look at the phrasing of all of it, it says that as if you were writing a contract, that, oh, this is my like how I want the scope of my stuff to be, if you read that. So that was November 9th. And on November, after that, they had the negotiations, blah, blah, blah. Like, it seemed reasonable, because here she's not really, blaming them for anything. She's like, oh, this is what I want, and protection. Absolutely. Like, even in the email by the lawyer, it doesn't say that this is, this has happened. And on January 4th, when they have that meeting, this is the list of 30 things that she put in her CRD complaint. And that's where she says, no more, no more, no more, and all of these things. But the fun fact, or not fun fact, she never shared that with anybody. That was never sent to anybody. It was spoken in person, and she misrepresented in the CRD that, oh, they discussed all the things and agreed that those didn't happen. And even, the Sony representative was there, and also another producer was there, and the producer even said that, oh, he left the meeting shocked, and they resumed the next day. So all these three things, it shows that her avoiding not making a formal thing, because had she done a formal thing, they would have investigated. She had avoided to have an investigation. That's three. And fourth, when she did complain the CRD, if she did wanted the neutral, party, the government would have done that for them, right?
Yes.
And that is this is 4 times of showing that how all of these were intentional for the, I know some people say, but it was for the movie rights, or the franchise. And I don't think the franchise is the movie itself. It was more like Colleen's fandom, because at the end of the day, she wanted to be a producer. It wasn't just about the movie. And the last point, remember, Omar, I had asked, sorry, I need to take a breather. My lungs.
You're good. Take as much as you want. Yeah, you're good.
Sorry. Remember, I asked Omar a while ago that in the FAC, in the FAC, in the footnotes, I had found that they made a remark that actually on the Lively accepted her role December 20th, and now they're refusing this investigation because there was no longer that workplace. And now I'm like, oh, maybe they applied, not now, but when I had asked him, maybe that's why they did the CRD complaint on the December 20th, because by then the workplace would have ceased. Maybe there was a contractual thing that ended everybody's participation December 20th. That was one thing that came to my mind.
Yeah, well, they repeated that in this letter. They literally did. It's so you're trying to investigate. You're trying to conduct an investigation for a workplace that no longer exists 2 years after the fact. That's bullshit. We need to know what you're trying to do. But it appears I understand better now what they're trying to do. It feels like they're just trying to intimidate the witnesses. They want a list of witnesses. Why? So they could extort them and try to shake them down and threaten to expose 10 years of text messages if they say the wrong thing.
Then there's got to be one point where somebody comes across a witness who's like, extort me for what, you dumbass?
And another thing that I was saying, that one of the things that I think they went to the New York Times, how Harvey Weinstein was exposed and everybody started coming out, oh, this also happened to me. I also think that they were hoping somebody would come out, and they effed with the wrong person, really. They thought everybody was like themselves, and they really didn't think that they didn't think not just Baldoni, like Jamie and Sarowitz, like they didn't think that they could find anything on, like they probably thought they will dig up something, right? And they can't believe that there are actually people who just live life like without doing harm to others. The worst thing they found was toxic positivity. They haven't even found stuff on Sarowitz. There was time I saw that people were trying to do something. And it's just been like they couldn't get the cease and desist. They couldn't get the AEO. And I think right now they want a gag order, probably. That's why they're doing this, because people have started talking. And also potentially is that I guess Friedman has the full right to have sanctions because of the Van Sham, right? If it is like he might be able to write it, and I think, oh wow, that's strange.
That's Anita's website, by the way.
That is Anita's website. Yes, we'll get to that. Go ahead.
Yeah, and also another thing that I was thinking that, what is it called? Potentially, like I don't know. Was it not actually Golding? She was saying that, or maybe somewhere, just like, oh, maybe one person had a sanction and then the other one had a sanction and then it makes it moot or something. I'm not sure if that's true. So I think that it's preventative, and also the audacity of them calling this a third-party investigation, like, and blaming them for potentially witness tampering while striking a letter where Friedman did the same. At least Friedman was in opposing litigation, like with them. This is like a third-party, company.
Help me understand though. Okay, so I understand. Well, okay, I get that during the course of their investigation, they're not going to disclose who they're going to interview and all this other stuff. And they're conducting an investigation. But is it the case? Do we know that the results of their investigation are not going to be provided to all parties?
No, Friedman, I think they said that it's up to them to this, like later on, like it's not like it's their, work document. Basically, it could be part of their work document as well. Okay. I think that's what I understood it. And plus, like it's a month and a half away from the deadline. So they're asking it so early on. Yeah. Because I think the discovery is supposed to end July, I believe.
It's been indicated already that it may or may not be work product doctrine. And so maybe that's what it is. And so their point in stating that we're entitled to at least, I could understand them stating that they're entitled to the results of the investigation, but I could also understand Wayfarer claiming work product doctrine because they paid for it. There's nothing preventing the lively parties from doing their own independent investigation, for example. I was making that point, but I think more aptly, if they're to the extent that they're trying to get the identities of all the people they're going to talk to, I wouldn't give them any of that stuff while the investigation is pending. I don't want them getting their hands on a list and like trying to send their people to extort or shake down potential witnesses or affect the integrity of the investigation. That's probably already been an investigation. If they're shaking down Taylor Swift, I mean, who else?
I was going to say that they should like write that, what is it? Lively wants a list of these people so that she can silence them, the way she's been saying that, they want a list of people they couldn't speak up. I think that's exactly the same. Yeah. And literally, if you read all their sanction letters and everything, it is everything they have been doing. Gaslighting 101. Like it's ridiculous. It's you can write a list of 10 things and they're guilty of the 9.
I'll give you yes. And the other to that degree, why is it that all of the potential witnesses in this case are all like getting in a beef with Lively's side? Why? Yeah, that's wild to me. But to help you understand the attorney work product privilege a little bit, it's like if I conduct an independent investigation by myself as an attorney, like I go to the scene of a crash site or whatever, and I take notes. You don't get to discover that. You don't get to know the results of my investigation. If I send out an investigator to go interview a client when I'm not present and I get the notes from my investigator, I don't have to give that over to you. If I don't intend to use it, maybe if I'm going to use it, then yeah, sure. But if I'm never going to use that, that is me working up my case. I'm entitled and privileged to not have to turn that over if I don't want to. I mean, there's exceptions to that. Like if it's
what
a
if
criminal
somebody comes
case.
out, somebody involved in the crash comes over and says you're not allowed to take notes and investigate this. You're not allowed to do that.
Kiss my ass. I'm taking a note right now. If you telling me that, how about that? I mean, I'm just saying there's a reason. I can understand both aspects of it. If it were me, I deal with independent investigations all the time in civil cases and family law cases, in cases involving CPS. There's always an independent investigation, and usually it's the courts that hire independent companies to conduct these investigations, and they're not all forthcoming about all the things that they're doing, but we always get the results. Well, not always. Sometimes we get the results of their investigation. Sometimes we don't. Sometimes they just write letters to the judge, and then it just becomes like a thing. But it's not an uncommon thing that you have an independent firm conducting an investigation. The audacity that they think that they get to learn the blueprints of their investigation before it's concluded is a little bit much. And so, yeah, I'm with the Wayfarer parties that they shouldn't be entitled to any of that. The bare minimum, they may be entitled to useful information that they intend to bring to trial. But if the Wayfarer parties run across stuff in their investigation that they don't intend on using because maybe it's not relevant, they shouldn't be required to turn that over to the other side. They just shouldn't. Not relevant.
Especially she has already gone with the CRD to forego the investigation, right? So unless she goes back and then she asks for an investigation, she has the full right to hire her own people, right?
Yeah, she has every right to hire her own firm to conduct their own investigation.
And based on this, I understood that people have already had interviews, so they're asking for voice recordings and stuff. So she like, if she has those people, the other actresses who had complaints, then like, wouldn't she just go and ask them directly? So,
I think that if there was merit to her SH claims, that she would have allowed for the investigation to continue.
She could have just given them the names of the 2 or 3 people that she says had other complaints. It would have been easy as hell. So.
Even if there's nothing found in that investigation, there's no harm in somebody investigating and making no findings. There's no harm in that. There is harm in them investigating and stating that, these allegations are unfounded, meaning there's no evidence to support. That would be damaging. But most of the time, like 90% of the time, these kinds of investigations are inconclusive, meaning that, I don't know, go either way.
Stephanie Barrett says Andy Signor, Popcorn Planet, love Andy by the way, is making a documentary about this. Says so many of the crew are scared to speak out for fear Lively, Reynolds, and WME will get them blackballed in Hollywood. I just want to say I can second that. I've talked to some members of the crew and some people who worked on this film, and they've echoed that sentiment. So like there are people who want to speak up, they just won't or can't at the moment. And if it comes down to it, if they have to attest to certain things, they will, but they don't want to kind of like destroy basically their career prospects if they don't have to. And that makes sense. So
you have a couple that is trying to broker deals with Hollywood folks and make or break careers and bragging about it. And not just this movie, but in subsequent movies and works that they've done. Why would you be all gung-ho about speaking out against them specifically, even if
you don't fuck with WME if you don't have to.
Yeah. That just
that's why they said that, their Friedman is also willing to take on the WME.
Yeah.
So.
Oh man! All right, guys. It's almost 2 a.m. here, so I gotta think about getting to bed. But is there anything else we meant to go over that we didn't? I don't.
You have to ask Anita because I know that she works.
Oh no! I'm just honored to be here. Thank you.
All right.
I got everything out that I needed to get out, and I apologize.
Yeah.
I mean, if you're trying to get a hold of me, I was with Lauren. My phone is. I'm looking at my phone.
No,
right
she's with me now, bro. You're done. She's with me now. All right. I guess she heard me screaming from across the Pacific and thought I better go help Lauren.
I just woke up literally, and then I saw you guys were going live, so I just said, "Oh, now I'm gonna go continue with my day."
I felt it telepathically. She
right.
had something to say, and she said it. So, all right.
I think it's time to call it. Thanks everybody for being here. We appreciate you, and I'll see
We love you
tomorrow.
all.
So.
Have a wonderful night. Be safe.
I love most of
Good
you.
night.
Not all of you. I'm gonna let you guess which ones.
I know which ones.
Bye.
Bye, Anita.